All right, good morning. It is March 26th. We are taking up H98, followed shortly thereafter by S95, and possibly discussing how we can combine the two. And we have Ledge Council with us.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and we're taking a look at H98 as passed the House. So H98 is relating to what are commonly referred to as confirmatory adoption. So we're working in the adoption law, but I want to talk a little bit first about our parentage law as like kind of laying some foundation here. And when and so we're talking about the establishment of parentage and who is a parent. We're not talking about parental rights in any way. So we're not talking about the things that flow from once you've established parentage, like care and custody and where they go to school and whose house they're at, that kind of stuff. We're just talking about the legal establishment of parentage. And about like 7 years ago, the legislature embarked on a pretty big project and created a whole new title specifically on parentage. You might recall this was Justice Dooley's last request of the legislature before he retired. He came and he sent a letter to Judiciary committees and said, please, our parentage laws are very antiquated. They don't.
Is that the Jansen Wilhoit kind of run that? Was he the lead in the House on that? Because I kind of remember parentage.
I think Jansen was before we did the parentage law. So the statutes before that time were pretty antiquated, and there really wasn't much, and it didn't reflect the way today's families are formed, which is by many different methods. And so the legislature created this new title on parentage and identified the various legal paths to establishing parentage. And just kind of a little overview, and I'll give you a handout too, so you just keep it in your file. So you can establish parentage through giving birth to a child. You can establish parentage through adoption. You can establish parentage through what's called a voluntary acknowledgement of parentage. So anybody who's got kids might remember maybe in the hospital, they give you a bunch of forms to fill out. One of them is a voluntary acknowledgement of parentage that kind of goes to the health department. If you didn't sign one, no worries. I think you're probably still a parent.
I just did it like 2 months ago, so.
Oh, okay.
Yeah.
And then there could be an adjudication based on admission of parentage. There can be a presumption of parentage. So that's something like a child is born during a marriage, and then both people in the marriage are presumed to be the parents. There's de facto parentage. That's kind of when someone is, child, there's a number of factors there to assess de facto parentage. But it's like oftentimes if you have a partner and they're living in the household, they're taking care of that child every day, they're driving them to school, there are doctor's appointments and things like that. You can have a court take and adjudicate that they're basically acting as a de facto parent. There's genetic parentage. There's parentage through assisted reproduction. And there's parentage through a gestational carrier agreement. So the law, under current law, we're not changing any of those things, but I just wanted to kind of remind you of the many paths to legal parentage. Mm-hmm. And so I think the existing law covers folks in terms of Vermont. However, there are many people, particularly same-sex couples, who, while they have established legal parentage here in Vermont, once they leave the jurisdiction, they're at a little bit of a disadvantage in terms of if they were in another state, another jurisdiction, there's the possibility that that other state might not recognize them as a legal parent, even though they're recognized as a legal parent here.
Can I just stop there and ask, are we then talking about somebody who's a state that is who's refusing to honor located credit for themselves? Are they in the wrong legally because same-sex marriage is legal in the US. And so if the state says they're not going to recognize a same-sex couple as parents, are they in contravention of the law?
So, so parentage and family law is like a state creature, right?
Okay.
So, different states have different laws, and generally around these issues, they're pretty much the same. I think there is kind of a heightened concern now that things may be changing in some states. There may be more in some states of a risk that that your parentage would not be recognized in another state, depending on that other state's public policy. And so for purposes of full faith and credit, generally full faith and credit is so that there's a provision in the Constitution that says that one state has to generally recognize the public acts and judgments that are issued in another state. And that's to make sure, you know, just for comedy and everybody getting along. And however, there's a difference between recognizing another state's statutes and another state's judgments that are issued by a court in that state. And if the public policy of the state that's doing the interpretation differs from the other states, they can say, well, we're not going to recognize it. This is contrary to our laws. So let's say if you say, like Alabama, right? So if Alabama says our law says we don't recognize these types of parents, and if you were here, you wouldn't be able to establish parentage, even though the home state recognized the person as a legal parent. There's some room there for Alabama to say we're not going to recognize that. However, if it's a court judgment, there's really no wiggle room there. So the U.S. Supreme Court has made a distinction in terms of other states' recognition between the statutes and the court decisions in terms of what absolutely must be recognized. And so in the case of adoption, so let's say you have a couple, let's say you have two women, let's say they're married here in Vermont. They decide that they want to have a child together and go through assisted reproductive technology. One of the requirements under the law for legal recognition, if you use ART for parentage, is you have to consent to it. And then, so there would be a couple different ways that, let's say, the non-biological mom would be recognized as a parent in Vermont. One is the child was born during marriage, and two, that the non-biological mom and the birth mom both consented to have a child together through assisted reproductive technology. And so there's two ways there, right? That that person, that non-biological mom, is recognized as a legal parent. However, if they went to another jurisdiction that had very different laws and they chose not to, then there's some ambiguity, some legal risk there that other state might not recognize it.
And maybe this is jumping ahead. So a confirmatory adoption is the act of a judge, and that has to be
exactly. So what happens, and what has been happening for a long time, is that many couples in those situations, the non-biological parent will petition the probate court to adopt their child, even though it's their child. They went through the whole process with
And they do that in Vermont.
and they do that in Vermont, right? And so couples do that not infrequently. To have that court judgment that says, you are a legal parent through adoption. So it's like, belts and suspenders.
Even though we've recognized.
Yes, it is really around portability.
Okay.
And so the idea of this bill came up because when you think about adoption, and if you think about, someone adopting a child who is otherwise like a legal stranger, perhaps not even living at home at the, like all of these things. There's a whole very long, complicated process for adoption. Includes things like criminal background checks and home visits and a variety of things that might not necessarily make sense if you're really looking to adopt your own child. as kind of a formality. Right? And so what this bill does is it provides kind of an expedited process for folks who are in that particular situation. So this bill says essentially for people who are already legal parents in Vermont, if you are a legal parent in Vermont and you want to adopt your own child, we're not going to make you jump through all the hoops that you would normally have to jump through.
Right. Got it.
Does it happen a lot? Is this practice like if somebody goes through assisted reproduction, does that center say, hey, just want to give you a little high level at the states where you might want to go down this route as well? Or is it?
No, I think, anecdotally, I will just say that because I've worked on these issues for a number of years, is that a lot of couples, and this is not gender-based, and it doesn't apply just to same-sex couples. It could be an opposite-sex couple who has,
So
had a
you-
child through ART.
So you go through ART and what if it would come into play if you both utilize like the mother's eggs and the father's sperm, right? Because that's creating a child of your own genetics,
Correct.
right?
Yeah.
But
So
if you had
you'd
a
be a
donor on either side,
Yes.
then this would come into play.
Yeah, if you had a donor gametes or
What was that word?
gametes.
Okay, I'll use that.
Yes, and so what has happened, like, going back before marriage equality was the law of the land, all this other stuff, oftentimes, same-sex couples would go to attorneys to try to create the legal framework of what generally marriage afforded, especially around like parentage and things like that.
Adoption.
And adoption, very popular. And so it's interesting. So since this bill's been percolating through the General Assembly, to hear a number of people just in this building who are like, "Oh yeah, we did that. I adopted my child." So it is. I think it is fairly common. And I think once you hear testimonies of some of the testimonies, like really kind of felt insulting is that we decided to finally go and just because we're going to be traveling or we have relatives in Texas or whatever it is, that my kids 3 and 5 petitioned because I'm not the biological parent, even though I'm a legal parent, petitioned for adoption, and I had to get fingerprinted. I had to have somebody come into my home on multiple occasions to do home visits to see if I'm a suitable home to be an adoptive parent, and they've actually,
Right, with their own kid.
yes.
Yeah.
And so it's not, the existing law is not necessarily just a very good fit for those particular circumstances. There's also like a provision in law around step parent adoption, but again, that doesn't really quite fit in these circumstances either. And so there are 9 states now that have this type of confirmatory adoption process. And really what it's doing is just trying to kind of move things along more quickly, take out some of the things that don't seem necessarily needed in this particular circumstance, and but also get it before a judge to make sure everything is good, and to issue the court orders so that the parentage will be recognized outside the relationship. So I'll just draw your attention to the language. So the definitions, these are definitions that are currently, so we're working in Title 15A, which is your adoption title. Title 15C is your parentage title, but these are the same definitions that we use in the other title. If you look at page 2, starting in subsection B, so whenever a child is born as a result of ART and the person or persons who didn't give birth to the child are parents, and that reference is to the consent to ART, that 15C BSA section 703. Or a presumed parent. Presumed parent is someone like when you have a child born during a marriage, or you're what's called like a holding out parent, which is that you live with the child, you take care of the child, you put them to bed at night, put them to school. So if they're already legal parents and they want to file a petition to confirm the parentage through an adoption, then they can do that with the probate division. Subsection C is just the types of things that are supposed to be in the petition, so it has to be signed by all the parents.
Michelle, can I
Oh, sorry.
just interrupt?
Sure.
I was thinking about this in general with subsection B. Why and maybe you already covered this, but why are we saying adoption, confirming adoption rather than just a court order confirming parentage, the same way, I believe they would confirm parentage if there's some uncertainty and somebody takes a paternity test and they say, you want to father? Yeah.
I think I would, I haven't really thought that much about it because you can get court orders attesting to parentage through other avenues under Title 15C. I don't know. I think this is just the approach that folks have taken. My guess is that it's probably a little more affordable and recognized. Adoption is such a core thing in family law, and we do have a U.S. Supreme Court decision specifically saying that states have to recognize the adoption decrees issued in other states.
Would it be stronger to say that? Because I'm envisioning a world where U.S. Supreme Court decisions just are getting overturned left and right. I'm just being concerned about the future. But let's say if it is a court order confirming parentage, is there more strength there if people are going to other states where there's uncertainty?
I don't see any difference there, but I'll think about that. And it might be a good question for the witnesses in terms of there were a couple of great witnesses in the House. Polly Crozier from GLAAD, who works on these issues nationally, and she's been before this. She was one of the people who helped us as an expert on these issues when we were developing the parentage law. And she's got a good sense of what's going on across the country and why different approaches. And then Meg York, who is someone here locally who's an expert and used to be at the law school, but she worked with the work that she works for. And she has a lot of experience with Vermont law. But thank you for the question. She'll think about that. So back to subsection C, you file a copy of the marriage certificate if you have one. Subdivision 3, declaration signed by the parents explaining the circumstances of the child's birth through assisted reproduction. It has to be to their consent and stating that there are no other persons with a claim for parentage under the law. Remember, you can't have more than 2 parents, right? Because there can be a variety of situations in which you can't establish parentage. So you have to have a copy of the child's birth certificate. Top of page 3, the filing of the petition is the consent to adoption. Subsection E is that is just a clarification of the existing law, which is that someone who is a donor of sperm or egg is not considered a parent. And so this is that's just kind of noting that you don't have to notify that person about the adoption.
Can I ask that? Is that in all 50 states, or could us, let's say, southern state say, if you donated the sperm, if you are the biological father, then could that be contested?
I think if you are, just in the context of recognizing parentage, it's possible. Again, if the state laws conflict, there is the ability for the other state to possibly say, for these purposes, we're not going to recognize it. However, if we've got the court order, they don't have the state.
So it's all about getting above the statutory line. Or, I don't know if above or
Right.
getting into the judgments. Yeah.
Right.
Yeah.
So subsection F Is the list of things that the adoptive parent does not have to do under these particular circumstances. So unless otherwise ordered by the court for good cause known and supported by written findings, the court shall not require an in-person hearing or appearance, although they might require a remote hearing. They don't have to have an at-home investigation, home study. They don't have to have a criminal record check. They don't have to check these federal databases around missing children, and there's not a requirement of residency period.
So this might be a question for the witnesses, but do you have any background or context on why not requiring an in-person hearing and why not checking the federal register for missing children?
For missing children, so remember, the person who's petitioning, they're already the parent.
Oh yeah, I get that part. I mean, I'm trying to think of it from the angle, in the very unlikely scenario that somebody's able to make it to this point, and it's actually a situation in which it's being done without another parent's consent.
Well, there's a requirement in here, and we'll get to the next one, but remember if you look back on subsection C, when you file your petition, you have to state that there's no other person with a type of parentage. Then we'll get here, I'll jump ahead a little bit to see if this helps, is that if you look at subsection G, which is on the bottom of page 3, court shall grant the adoption and issue an adoption decree upon finding that if it's in the case of marital parents and the person who gave birth to the child and the spouse were married at the time of child's birth and the child was born through an ART, that's the one finding. But if the parents are not married, it's that the person who gave birth and then the non-marital parent consented to the assisted reproduction and no other person is a claim to parentage pursuant to Title 15C. Or if there is someone who has a claim to parentage who's required to be provided notice or who must consent to the adoption has been notified or provided consent to the adoption. And so this kicks you into another section of the adoption law around who is required to consent and who isn't required to consent. I think an example of that might be, let's say you had a couple who was married, divorce drags on, takes a while, they both start dating other people and have new partners, but they're working out the financials of the divorce. And woman with her new partner wants to have a child. And so they consent to assisted reproductive technology, having a child through those means. And she has a child, but it's within 300 days of when her divorce was filed. So they've kind of like moved on and with other partners, the ex-husband has nothing to do with this child, is not looking to assert parentage with regard to this child, but there's a presumption because the child was born within 300 days of the divorce. So there's certain things you have to the court would have to kind of check off and assess. Which is why there's the ability for the court to be able to have a hearing and it not to just be administrative.
But it could be.
But it could be remote.
Yeah.
And I think in terms of like why not have to do those other things, are there dangers in that? I can try the witnesses better. So
Senator Mattis, you have a question?
It might be a question too for a witness, but like when you're at one of these facilities that do ART, do they do like a background or ask any background questions, or is it just one or two people sitting in front of the provider and all right, let's do it?
I don't.
Okay.
I mean, there's very prescribed things when you're looking under the law with regard to gestational carriers, and that is much more complex in terms of everybody has their own lawyers or certain things you have to do in terms of the gestational carrier contract, things like that. ART can be very prescribed. through the use of an outside party. And then I think probably the witnesses will also tell you that sometimes it's pretty casual. I don't know how to quite describe that, but that there's not necessarily going to a facility that has paperwork, that has all of these other kinds of things, that sometimes it could be agreement that, you know, a friend is gonna be a donor and they don't go through because it might be cost prohibitive to be using a service. And so I think there's many ways that people access the RT. But I think probably the witnesses can talk to you more about what that looks like.
And just to add on to that, oh, thank you. I think that perhaps one of the reasons that it may be more casual is, you know, the right to have kids and raise your family, as you said, that is considered a fundamental right. And so it's very difficult, you know, it rises to the highest level of strict scrutiny, where it's very difficult for a government to say, here are the rules when it comes to whether or not you can have kids, or, you know, whether or not you have to hypothetically not be a felon or not have, you know, mental illness or something before having a kid. So that's why that's, yeah, just my 2 cents.
Subsection H, this is just in the circumstance where there is someone who has another person who has a claim to parentage and the notice providing, and this kind of just links in with the provisions of adoption. I would say the circumstances under which there's going to be someone who has a legal right, has legally established parentage, who is not part of the action for petition for divorce and doesn't know things like that, it's going to be very, very small. Generally, you know, these are going to fall into the category of, you've got a couple of people decided to have a child through ART, they're going through the vision of their claims to parentage. But there is a process here for the court to be able to ascertain if anybody does have a legal claim to parentage and whether or not they have to consent under the adoption law. So page 5, subsection I, is that petition to adopt is not to be denied on the basis of any of the petitioner's parentage is already presumed or recognized. So, you know, the court could say, well, if you're already legally recognized under these 2 different statutes in Vermont, therefore, you know, you don't need the adoption. And then subsection J is that when parentage is presumed or legally recognized under the parentage law, the fact that someone didn't petition for adoption is not to be considered as evidence when 2 or more presumptions conflict, nor in determining the best interest of the child. So best interest of the child is used in the determination of like some factors around parentage. When there are conflicts between people who are starting parentage. And this is just saying that, you know, because somebody didn't avail themselves of the ability to get adoption doesn't mean that it was necessarily still be illegal here under the law.
What was
No.
Thank you. Maybe any questions or comments at the moment?
Thank you.
Yeah. Okay. So just got the list of witnesses that the House had, so we will end up hearing from some additional folks. And we'll take it from there on this particular bill. We also have S-95, which it is my hope will end up being germane, since it deals with children and guardianships. And it also wades into the area of immigration proceedings. So 2 different categories, but does have to do with children and custody for those children. So perhaps it will be.
If we just make a committee level for both things.
That's what I was thinking. Or we could just attach S95 to H98.
Yeah.
And then,
I was just thinking to get rid of the question of whether it's germane.
okay, yeah, that's a possibility. Yeah.
I don't think anybody would challenge.
Yeah.
This topic, but
Yeah, maybe like that works too. So. Eric is doing S95.
Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough with the committee of S95, which is an act relating to standby guardianship for children whose parents have been subject to adverse immigration actions. As the chair just mentioned, what may not be relevant now, the germane issue, depending on what process you decide to take moving forward with the two bills. But one thing I noticed as I was listening to Michelle's walkthrough is that both of these bills deal with expedited proceedings in the probate division involving children and parents. So there's this connection there between the types of proceedings that are going on and where they're going on. So they're in the probate division, they're involving children and parents, and they both involve creating kind of an expedited process for a particular type of situation. Michelle's involved adoption. This one involves guardianship. They've got these, and both those proceedings do take place in the probate division of the Superior Court. And the one that we're looking at now with respect to S95 has to do with guardianship. And in particular, it has to do with guardianships for children whose parents have been subject for what the bill defines as adverse immigration action. So to think about that for a second quickly, just there's going to be a number of different ways that term is defined, but the most, I think, the most common and most sort of self-evident one is when you have a child whose parents are detained by law enforcement authorities for purposes of alleged violation of federal immigration law. So that's the situation in which the proceedings that you have in front of you in S95 will come up. But what the bill does is it proposes to establish an expedited guardianship process for kids in that situation. So, and you already have to sort of think about what it's being folded into with existing law. So this is, first of all, it's going to be a voluntary guardianship process. It's consensual. In other words, this isn't a situation where, because there's also a provision in law for involuntary guardianships when the parents actually oppose the creation of the guardianship. This isn't that. This is a voluntary consensual guardianship. So it's kind of tied in with that proceeding. And in addition, you also have provisions in existing law for expedited processes, certain situations. For example, if the parents are unavailable for some reason, they may be medically incapacitated, they may be dead, they may be that the parents can't be located or that their whereabouts are unknown. In those situations under the existing guardianship statute, there are already provisions for some expedited proceedings. So you think that makes sense because if you're in a more of an emergency situation, in fact, it's called an emergency proceeding under the existing law. And some of the processes that you ordinarily require in a guardianship proceeding, like provided notice to all the interested people, like having a hearing before you establish the guardianship, those procedures are essentially set on hold in the emergency situation. So you can bypass them. If, for example, parents are in one of those situations that I just described, maybe they're medically incapacitated, can't be located, no one knows who they are, if their identities. So this, in a sense, adds one more category to that list in which you could have an expedited proceeding. And that category is the parents are subject to an adverse immigration action. For example, they have been detained by law enforcement authorities for purposes of an alleged immigration violation. You can sort of think conceptually that sort of a similarity there in the sense that they're not available in the same way. And in fact, the definition of the adverse immigration action specifically says parents are unavailable to the child because of this immigration action. That's something that the parents will have to show in order to essentially get the benefits of this process. So that's the background of the idea, that it creates this expedited guardianship proceeding. If you have children who essentially, through the parents being detained, might otherwise end up in state custody, right? If they don't have a guardian. So this allows the guardian to be created more quickly than it ordinarily would. It's got some time frames in it that are speeded up as compared to the way that would be in your typical long-term guardianship. So that's the big picture. And the mechanics of it are set out in detail in S95. That the purpose and the general procedure of how it works is how I just described. So we'll go through some of the language just so you can see how procedurally it operates. And you've got the definition section in the beginning of the bill, for example, you can sort of adding in the very first definition, an expanded definition of what a child in need of guardianship means, and then you're just adding the situation that I just described. If the parent is unavailable to care for the child because the parent has been subject to an adverse immigration act, so it adds that criteria to one where you can file this guardianship petition. The adverse immigration action is defined on page 4. You'll see there's a lengthy definition. I'm just focusing on the first one, subdivision A, line 7, page 4. Arrest or apprehension by any local, state, or federal law enforcement officer for an alleged violation of federal immigration law. So that's, as I say, the most sort of obvious and probably the one that leaps to mind when you use the phrase adverse immigration action. Those other ones sort of B through F. I'm not going to get into in great detail right now. Those I think involve some specifics and minutia of federal immigration law, about which I'm not an expert. You may want to hear from your witnesses about that.
I'm just wondering, Eric, on page 4.
Yep.
So when it says arrest, detention, or custody of Department of Homeland Security, is that as opposed to immigration, that's like terrorism, domestic terrorism, or something?
That's why, as I say, I'm not sure. You want to ask your advocates who have been opposing some of the language in this bill what they intended to encompass by that language, because I'm not. I noticed the same thing. That seemed broad.
Yeah, I believe ICE is under the umbrella of the Department of Homeland Security, as is Customs and Border Protection, and there are many other agencies. I mean, I was wondering similarly on that subsection.
Subdivision, we need some defined.
I almost said subdivision. If we want, if we want to make it, if we would want to consider removing the Department of Homeland Security and just saying arrest, detention, or custody by any federal, state, or local agency engaged in immigration enforcement, that broadens it a bit or makes it a bit more.
Yeah, I had the same thought, because when I read the language, it seemed to me that any arrest, detention, or custody by Homeland Security would be encapsulated in the way the language is written now, not necessarily limited to immigration proceedings. And so that was the thought that occurred to me, and I kind of turn to the witness and say, am I missing something then? But yeah, I think you're right, Senator Hashim, in some way, including some language that clarifies that it's related to this arrest, detention, custody has to be related to, making an alleged violation of immigration law or something along those lines.
Yeah, and well, I'm wondering if the intention was to keep it broad, or because. But I mean, Department of Homeland Security is, two, American citizens could be arrested by the Department of Homeland Security, and they could have a kid, and that could fall under this category. I mean, I'm not opposed to having that kid being able to go to a guardian instead of just being pushed out onto the street or into state custody. So, but it's also not related to immigration specifically, right? So I think maybe we should bookmark this to revisit. Right. Senator Brew, did you have?
No, that was all my concerns.
And if you did say, and in some ways, if you did add in language, something along the lines to tie it to, an alleged violation of federal immigration law, well, then how would that be different than we already have in A?
Right. Yeah, it seemed, I was wondering if it was trying to get at some other, like,
Right.
in some other field of, law.
So, yeah, good question for witnesses. I have the same query. So leaving aside the definitions, focusing for now on the general concept of the alleged violation of federal immigration law, that's an A, that being sort of the reason on the basis of which someone could file one of these petitions. So let's move on to the procedure itself. It starts on page 5. So this is all existing law on page 5, gives you a sense of how this ties in. So right now, if you want to try and get a guardian appointed, you file a petition in the probate court, and that could be filed by the parent or by anybody who's line 3 of page 5, interested in the welfare of the minor. So anyone with any interest in the child's welfare can file this petition in the probate petition. And if you start on line 6 there, that's a list of what the petition has to include. So you can do a lot of identifying information, specific reasons why guardianship is sought, that sort of thing. So that has to be included in the petition. And what the bill proposes to do is add a couple of things that has to be included in that petition. That's over on the next page 6, 11 and 12, lines 3 and 6. So these have to be, so if we're going to file a petition, it has to include these two things now. And this is specifically related to the process that's being created here for standby guardianship. See, so you have to say in the petition number 11, whether the petition is seeking the standby guardianship, to lay that right out there, and the reasons for it, including what is this adverse immigration action that the custodial parent might be subject to. So that has to be stated in the petition. And then number 12, whether it's an emergency petition. So as I was just mentioning, there is a provision in existing guardianship law that allows emergency petitions can be filed. So this is kind of tied into that process. So if you look, we're going to skip for a second because it references this right here onto the next page, page 8. If you look at page 8, this is the emergency guardianship language. And this is on page 8, line 8. Subsection F. So you have this provision right now. Court may grant an emergency guardianship filed ex parte, and that means you're filing just on your own, without providing notice to any of the other parties. You know, that specifically allows these ex parte on your own without providing notice. Emergency guardianship petitions to be filed in certain situations and under existing law. Remember, I mentioned this earlier. Looks like line 12. I've kind of written it up here. What are the situations when you can file one now? If both parents are deceased or medically incapacitated. See that? So this adds to that list another situation in which an emergency petition can be filed. And that's, look at lines 14 and 15. In case of a standby guardianship, custodial parent has been subject to an adverse immigration action that renders the parent unavailable to care for the child. So the parent's unavailable to provide care for the child because of an adverse immigration action. That's another avenue for which you can file this emergency petition. After you file the emergency petition, as we just said, then you don't have to give notice to everybody else. And line 16 and 17, the guardian can be appointed without delay before hearing. So those are kind of expedited processes here that we're talking about. You don't have to provide notice, and you can appoint a guardian pre-hearing. If that hearing as soon afterward as you can, but you can do the appointment right away if you're in this emergency situation. All right, so turn back to page 6 for a second. And we'll look also at what this is the service point I just made. So generally speaking, when you're filing this petition for guardianship, it has to be served on all the parties, right? That's lines 8 through 10. Petitions should be served on all the parties and all interested persons. However, look at line 11. This is existing law still. The probate court can waive these notice requirements under certain circumstances. In the existing circumstances, line 14, 15. So the service can be waived if they don't know the identity of the parent, or the location of the parent is unknown and cannot be determined with reasonable effort. Again, adds another way, another circumstance to this list under which you could have an emergency feature, which is that service is waived. All right, so you don't have to serve. You don't have to serve everybody. You don't have to serve all the interested people, the parents. If starting on line 17, custodial parent is detained at the result of an adverse immigration action, and the custodial parent is unable to be contacted after reasonable effort. So again, you can think of the concept. The concept is these different ways that the parent is unavailable. Either, they're medically incapacitated, they passed away, they don't know who they are, their location is unknown, they can't be contacted. Those are existing ones. This is adding into that parent is detained. because of an adverse immigration action. Say in those situations too, we're going to let this emergency guardianship process go forward, even though we haven't had a hearing yet and we haven't provided the same way it can now under certain number of emergency situations. So that's the idea. So having said that, all right, well, what does that process look like? That starts over on page 9. And this is the sort of written, enacts this new statute within the guardianship chapter, starts on line 2, page 9, consensual standby guardianship. So that's what we're talking about. Remember I said it was consensual. This is a situation where the parents consent. And in fact, if you look at, starting right there at line 3, this petition has to include a consent. That's line 4, consent form signed by the custodial parent, attesting that the custodial parent understands the nature of the standby guardianship and knowingly and voluntarily consents to it. So they understand the nature, they voluntarily consent to it. I should add that exact same language, this and much of what you see in the section is already in your usual consensual guardianship statute. See, this is the 2626A line 2. 2626 is your is consensual guardianship. And so it's a general procedure. This adds some additional timing, expedited elements to it, but otherwise it's very in some ways identical to the existing statute that has to do with consensual guardianships where the parents agree to it. They're not objecting to it.
So here,
Yeah,
this can only go forward if this is signed.
correct.
But what if the person is adversely detained, the parent, and can't sign, isn't allowed to sign?
If that's the case, and I think the notice requirements.
Probation, on page 6,
Right.
The probate division can waive the notice requirements, but over here you can't waive the consent. Is that right?
That's an interesting question. Whether the proceeding, because they can definitely go forward without, they can waive the hearing as well. The hearing doesn't have to be held prior to the establishment of the guardianship. And you're right that notice doesn't have to be provided either. So it may be that you want to add some clarifying that there, provide specifically.
Yeah.
That the consent form and as well possibly the agreement, because you see further down the page, they're also, well, that's the day of the hearing, so that may not be as much of an issue.
Yeah, I have that question as well, because as I'm reading it, I can see that notice could be waived.
Right.
And the hearing could be waived, but
And you wait, because you don't know where they are, dude.
Right.
How would you get the consent form?
but to actually form the standby guardianship looks like, regardless of a waiver of the notice, still requires the signed consent form.
Because, I mean, it's not like crazy. The news is reporting people being like pulled off the street by ICE agents and put in a van, taken to the airport and put on.
I doubt there was a take on that point and right here. Equal duties. You consent.
What isn't this part about the custodial parent? So it's the person that's gonna be receiving the child? That's different.
Are you on page?
Parent, on page 9, about the consensual standby guardianship. So like the consent signed by the custodial parent.
Now that does refer to the parent.
Oh, it does
As
refer.
custodian, yeah, so they're the ones who have to sign it and say, yes, I'm agreeing to this guardianship. In other words, that temporarily, at least, they're going to, the court's going to appoint the guardian to have responsibility for their child.
I would read it the other way, that this person received.
Yeah.
Yeah.
Well, yeah, that doesn't make a lot of sense, that it can't. By the person.
Right, so maybe that we want to get to the sense of the
And it's kind of
chronology
like,
of this.
it's kind of like it contemplates an immigration agency that's operating under, rules from 10 years ago, let's say. I mean, the Trump administration is developing their own rules now and fighting them out in court. And I just think this imagines that someone will be in a jail cell holding cell, and you would be able to have a representative go to them and explain and give paper. And that's not the way it's going down these days.
Right, and there is a specific provision, you see lines 12 to 14, that allows them to, the custodial parent to appear and participate remotely. But even that may or may not be available depending on circumstances. But, so assuming that scenario where the person really can be located and is in a detention facility somewhere, then they could participate in this remotely and agree to it.
Right.
But that's an if. I don't know if that would necessarily be the case for me. But if we presume that the parent is available one way or another, either that they had notice of the detention coming up, or that they were detained in a place that allowed some remote access. If that being the case, then they have to consent to the proceeding, and they can participate remotely, as I said, on line 14. They have to file an agreement. And again, this also tracks the existing language for consent for guardianship. There has to be an agreement signed between, and this is kind of what you're getting at, Senator Matos. Line 16, you have two different parties here, the proposed guardian and the custodial. So that's the other parents are the ones who are saying, hey, we're going to propose this other person to have rights and responsibilities over the child, at least temporarily. And this agreement has to contain certain things that are laid out there. You can see line 18 that the parties, and that's echoed what's caught there, that intended to the parties are creating a standby guardianship that's effective only if the custodial parent has been subject to an adverse immigration action that renders the custodial parent unavailable to care for the parent. So this standby guardianship only kicks in if that precondition is happening. And then you have a list of, this other information about the guardianship that has to be included in this agreement. The respective responsibilities of the guardian and parents. I'm over on page 10 now. The expected duration, if they know, parent-child contact. Subdivision F, line 6, is that the guardianship presumptively terminates if the custodial parent is released from custody and reunited with the child. So again, sort of goes to your point, Senator Matos, about once the parent is available again, then there's no need for the guardianship, and presumptively the guardianship terminates.
What happens in the case? I don't know if this actually happened or whatever, but what happens in the case where somebody's detained for one of these actions and they're moved out of state, and then they get released and they're in somewhere 1,500 miles away, and then they have to get back to their child? Does that still mean that as soon as they're released, the guardianship that's there is gone and that child's kind of just floating around?
Yep, that's a good question. And I think it's addressed by the fact that it says shall presumptively terminate. So that means there's a presumption that it terminates. But when a presumption happens in a legal process, it can always be rebutted. That's what the way presumption works. So if there was evidence, as you just mentioned, that, well, hey, in fact, in this case, the person is halfway across the country, and there isn't actually any immediate availability for the person to come back and be parent, then you can then the guardians would be permitted under that presumptively terminate language to introduce the evidence, say, hey, in this case, we think that that presumption should not apply for these reasons, and the court can say, oh, okay, we'll hold off on that until we say just what the court might say. So we hear back from you that the parents are back in state and they're available again. So it doesn't provide that option. But not that if it just said shall terminate, then you'd be in a situation where you probably want to add something for the presumptive, which they have in the first place, which is good.
Just some general information for the committee as of a month ago, regarding whether or not this is happening. As of a month ago, according to Vermont Legal Aid, there have already been 16 families that have tried going through this process, and 13 others are in the pipeline to go through something similar. Based on the context of this. So yeah, that was a month ago.
Is there any, I don't know if it's further down with you, Bill, but is there any concern? So say you have a situation like this, you have guardianship, and then the person who is providing the guardianship also gets detained for one of these adverse immigration. I don't know if it could lead to that somehow where 2 weeks later, the guardian finds themselves in the exact same position as the custody parent.
Yeah, it's an interesting point. That isn't actually specifically addressed, so it might be a good question for the website.
You could have, because these are triggered, right?
Yeah.
Consent shall provide, it's contingent upon the parent becomes subject to an adverse immigration action. You could have a whole chain of these where each person signs a consent. You know what I mean? Like their grandparent signs in case their daughter and their granddaughter are affected, but then they themselves might be deported, so they could sign one with somebody else. Right?
Yeah, you could. And you could, in theory, I guess, I also, I just know that generally speaking, you can have alternates. I don't know if that would apply, if they could do that, draft it this way. I know that, for example, when power of attorney, I think guardians in general, you can't, I know that, like, an example for a situation where, you can draft wills, that sort of thing, where you establish who is a guardian if somebody, parents pass away. You can have alternates as well. Well, if this person's available, they would move to that person. Possibly, you could draft it the same way here, but sort of thinking out loud.
Eric, did you have more testimony? Or,
Yeah, a little bit more. We're not quite to the end, but I can pause it.
oh no, I had a general question, but it would at the end.
Okay, sure. Yeah, so just a couple of last things. So line 12, page 10. So the court has to grant petition if it finds by clear and convincing evidence. So you see that the court has to make this finding in order to grant the petition and establish the guardianship, and all these things that the court has to find by clear and convincing evidence. You know, that's a strong, there's a high level of evidence, higher than preponderance, not as high as beyond a reasonable doubt, but very strong. Generally described as reasonably certain. So it's be reasonably certain that those factors exist, and the one that's most pertinent to what we've been talking about now is subdivision 1 there, line 14, that court has to find that the child's immediate guardianship because the parent has been subject to an adverse immigration action that renders the parent unavailable to care for the child. So the court has to make that finding based on the facts. Then there's a list of other findings the court has to make, which are very similar to the same findings the court has to make for voluntary guardianship. Generally, custodial parents not only involuntarily consented to it, they have reasonable effort made to notify the parent. The agreement is voluntary. Over on top, page 11. Both guardian is suitable, and the guardianship is in the best interest of the child. And again, as goes to your earlier question that I might have some presumptions in here again for a different fact in subsection E, line 3. There's a rebuttable presumption that the guardianship is in the best interest of the child. In other words, because the court has to find that under subdivision 6 of there, line 2. But there is a presumption that the guardianship is in the best interest if those other 3 facts are present. There was an adverse immigration action that the custodial parent was subject to that made the parent unavailable to care for the child. All the parties consented, and the custodial parent is represented by an attorney. So if all those 3 factors exist, then you've got a presumption that guardianship is in the best.
But if you don't have one, for instance, you don't have an attorney.
Yep.
You lose the presumption, but then it's just an equal.
Exactly. You can still show it, yeah, but you're right. You don't have the benefit of the presumption. Yeah, so that's essentially it. Just a couple, there's a section in the end of section, thanks, page 14, that has to do with termination and those are procedures for how one of the guardianships gets terminated. And generally speaking, the court has to, if the parents file a motion to terminate the guardianship, that's line 14, page 14. Generally speaking, that's existing law. The court has to terminate it unless the guardian objects within 30 days. So that sort of gives parents in the voluntary situation the opportunity, the option to terminate it. And the court generally has to do it unless the guardian objects. There's some specific pieces related to this provision though. So line top of page 15, this parent's motion to terminate, there's a specific provision here that doesn't have to comply with the sort of formatting and signing requirements that are usually required by the Vermont Rules of Probate Procedure. And that's envisioning this idea that maybe the parents might not be might be out of the country, might be in a situation where they can be reunited, but they're not here, so they don't have to comply with those particular formal requirements. And the custodial parent can appear remotely. That's line 12 and 13. If there's a motion to terminate this filed by the parents. Yeah, that's, I think covers the big picture and the details that I wanted to go over for the walkthrough.
Thanks. Yeah, the question that I had, you kind of touched on it right after I said that I had a question, which is, regarding the guardian is suitable and taking into consideration the best interest of the child.
Yep.
The only concern that I had, probably will still have as we work through this is, as it is the idea of potential guardians going through this process and it essentially being a front for some sort of human trafficking or just like I just worry about exploitation of children who are going through this pipeline because it's unfortunately easy to exploit people when they're when their life is being completely ripped apart. So, but knowing that there's the clear and convincing standard, and the best interest of the child factors are being considered, and that the guardian has to be suitable, that certainly alleviates some of those concerns. But just something I'm going to be keeping in the back of my head. Yes.
Yeah, it makes sense. And I think you're right, that the fact that you have this formal court process with a higher evidentiary standard of clear and convincing standard, they have to find suitability, they have to find best interest of the child. I think it's always the case that no system is foolproof, but that those are protections that would, or at least hopefully in most cases, ensure. And also that the probate division, that language, proposed guardian and suitable, I think that's exactly the same language, the findings they have to make. Suitability, proposed guardian suitable is also in the existing consensual guardianship statute. So in other words, the court is familiar and has expertise in making those sorts of findings as well, and knows what sort of evidence to look at. So that might go some way toward addressing that.
Thank you.
Yeah.
Any questions or comments? I think we'll line up some additional witnesses for both bills, and I'll figure out the logistics of whether we want to keep it a House bill or turn it into a committee bill and merge the two. Then we'll just be working on it. All right, we have another bill at H21 at 10:45. So why don't we take 15 minutes and come back at 10:45?